5 seconds to go. Start. It is totally misplaced as much as in paragraph 40, this court has observed thus, para. Before we discuss the merits or demerits of the aforesaid submissions, we would like to state that the law relating to conviction based on circumstantial evidence is well settled and it hardly requires a detailed discussion on this aspect. Stop. Suffice to say that in a case of murder in which the evidence that is available is only circumstantial in nature, then in that event the facts and circumstances from which the conclusion of guilt is required to be drawn by the prosecution must be fully established beyond all reasonable doubt, and the facts and circumstances so established should not only be consistent with the guilt of the accused, but they also must entirely be incompatible with the innocence of the accused and must exclude every reasonable hypothesis consistent with his innocence. Stop. Para. It will further be relevant to refer to the following observations of this court in the said case, para. The provisions of section 27 of the Evidence Act are based on the view that if a fact is actually discovered in consequence of information given, some guarantee is afforded thereby that the information was true and consequently the said information can safely be allowed to be given in evidence because if such an information is further fortified and confirmed by the discovery of articles or the instrument of crime, and which leads to the belief that the information about the confession made as to the articles of crime cannot be false. Stop. Para. A perusal of paragraph 71 of the said judgment would reveal that the court has reiterated that the two essential requirements for the application of section 27 of the Evidence Act are that the person giving information must be an accused of any offence and he must also be in police custody. Stop. The court held that the provisions of section 27 of the Evidence Act are based on the view that if a fact is actually discovered in consequence of information given, some guarantee is afforded thereby that the information was true and consequently the said information can safely be allowed to be given in evidence. Stop. Para. In the facts of the said case, the court found that there was, in fact, a confessional statement of the disclosure made by the appellant Gurbachan Singh, which was confirmed by the recovery of the incriminating articles. Stop. As such, the court believed the disclosure statement and the evidence led in that behalf. Stop. As already stated here in above, in the present case, there is no confessional statement of Boby, accused number 3, appellant herein, recorded with regard to recovery of the dead body of the deceased. Stop. Para. In the result, the appeal is allowed. Stop. Para. The judgment dated 18 December 2004 passed by the trial court, thereby convicting the appellant under sections 395, 365, 364, 201, 380, 302, read with section 34 of the IPC, and the impugned judgment dated 25th August 2008, passed by the High Court affirming the same are set aside. Stop. The appellant is acquitted of all the charges charged with. Stop. The bail bonds of the accused shall stand discharged. Stop. Para. Pending applications, if any, shall stand disposed of. Stop.